All right, good afternoon, everyone. I apologize for the delay. Kind of got held up in the governor's press conference traffic, so I do apologize for that. We'll get started now with the Governmental Affairs, State and Local Government Subcommittee. Chairman LaHood, would you open us up in a word of prayer, please?
I sure will. Bow with me, please. Lord, thank you for this day and for all the work that's been done here so far, and I just pray that you would continue to pour out your wisdom for us to guide us, and pray that our presentations today and the matters we take up, that you'll do just that, and just guide us with your wisdom. We thank you in Jesus' name, amen.
Thank you, sir. Okay. All right, I see Representative Washburn, and we have his bill listed first. I think it was a late addition. So just numerically, we'll call Representative Washburn to the podium, and you may proceed when you are ready, sir.
Thank you. Mr. Chairman, could I ask an unrelated question?
Yes, sir.
Why is this laptop here on this lectern open like this?
That's a good question.
Is it okay for me to close it?
Absolutely, yes, sir.
Thank you.
Thank you.
I never thought to ask that. I presented something in here a couple of days ago, and it makes it quite aggravating to try to balance everything. So thank you for.
Not to mention we don't want to knock it off. So
yeah,
thank you.
Thank you. Thank you and Chairman LaHood for adding me today. I appreciate the opportunity to present this bill. I'm here to present House Bill 1073, which is LC number 472657. It is, I know you always hear that it's a simple bill, but this one is a simple bill. It amends Code Section 3666-4 of the OCGA by eliminating subsection F. Now, let me read subsection F to you, and then I'll make some very brief comments. Subsection F of that code section is, when a proposed zoning decision relates to or will allow the location or relocation of a halfway house, drug rehabilitation center, or other facility for treatment of drug dependency, a public hearing shall be held on the proposed action. Such public hearing shall be held at least 6 months and not more than 9 months prior to the date of final action on the zoning decision. The hearing required by this subsection shall be in addition to any hearing required under subsection A of this code section. The local government shall give notice of such hearing by posting the notice on the affected premises in the manner prescribed by subsection B of this code section, and publishing in a newspaper of general circulation within the territorial boundaries of the local government a notice of the hearing at least 15 days and not more than 45 days prior to the date of the hearing. Both the posted notice and the published notice shall include a prominent statement that the proposed zoning decision relates to or will allow the location or relocation of a halfway house, drug rehabilitation center, or other facility for treatment of drug dependency. The published notice shall be at least 6 column inches in size and shall not be located in the classified advertising section of the newspaper. The bill we are proposes to remove that section, and I thought it was important for you to know what we were proposing to remove, so that's why I bored you with the reading of all those details. Simply stated, this bill removes all of that, but still allows local zoning to go through whatever hearing you would go through for any other requested rezoning. And so local government still has the power to review and reject a request for rezoning. I went to see Council Morelli about this to be sure I was correct about it, and also, and I would ask the distinguished council to correct me if I misspeak here. People who are residents of these type of facilities now are a protected class by federal law. Am I correct, Mr. Morelli? And so this bill is intended to do some things that we think should be done anyway, but it also brings us into compliance with the state law. And so I will yield for any questions.
Okay, thank you, sir. And we have a question, Chairman LaHood.
Thank you, Representative Washburn. I was just going to ask, and it might be a question for our led council, but the subsection that's being repealed, in this bill, subsection F? Is it normal to not have that written out in the new bill, maybe struck out so we can
I do not know the answer to that.
understand what we're repealing? I know you read it to us, and I
Yeah.
appreciate that.
Yeah.
It is one of the ways. I mean, we can do it either way. Usually, if we're repealing a whole subsection, we don't necessarily spell it out. But you know, it can be both ways, but it does not have to be, redlined in the bill itself.
All right. And so I think you explained what you're trying to do with the bill, and it's to come in alignment with federal law.
Mm-hmm.
And is it also bringing this type of facility, the zoning decisions and process into alignment with other property types?
Well, it is my understanding this is in the state code that allowed or required these beyond other uses. In other words, this is beyond what it would be to apply for other types of rezoning, and part of the intent of this is to make it so that you treat these kind of facilities just like any other facility would be treated.
So there would
and I
still
hope
be notice given to the public, and
It is my
public comment would
understanding,
still be collected.
Yes, it is my understanding that if there's a rezoning required, the normal process of rezoning will still be conducted, and anybody supposed to it will have every opportunity to come and speak against it. So it just takes away that extra requirement. And I should point out, I did not already, I'm happy to say that the Georgia Municipal Association is neutral on the bill, and I believe ACCG is here to speak in favor of the bill, actually. I think they've signed up to do that.
Okay, thank you. Representative Burnell?
Thank you, Mr. Chairman. I just have one question. It says, because we don't have the whole bill in front of us, it says zoning repeal additional hearings. So does that mean that if one of these facilities was moving someplace, someone had questions about it, that they would not have to have an additional hearing to make sure that the residents and the local government agreed with the relocation of these facilities?
It is my understanding that if somebody wants to locate one of these facilities and rezoning is required, that they have every right to go through the process for rezoning just as if for any other request.
But I'm asking if that community has other questions. So it's a possibility then that you could have additional hearings.
Whatever the local zoning requires, and that varies from community to community, I believe, with home rule and local control. So whatever the local community requires, they would have the right to do.
Thank you.
Okay, any other questions on the part of the committee? Seeing none, Representative Washburn, thank you, and we'll call Mr. Todd Edwards with ACCG to speak to the bill.
Thank you again for allowing me to present today.
Mr. Edwards, you may proceed when you're ready.
Thank you, Mr. Chairman, members of the committee. I'm Todd Edwards with the Association County Commissioners of Georgia. We're here to support this particular legislation. We believe that Representative Washburn stated the purpose, intent, clarity of the bill, and that it repeals that a certain code section that does require the additional hearing, notice, and 6 months for something that we believe is prohibited by state or federal law, the Fair Housing Act, and that we cannot treat these homes any differently than we could other homes. And Mr. Washburn was correct in that they would, all normal or other zoning hearings do apply. It's just that we can't go above and beyond something we agree, our attorneys agree, we were unable to by federal law, so this just clarifies it. And we did run it by our policy council at ACCG, and they opted to take a support position. We're happy to do so.
Okay, committee, any questions for Mr. Edwards? I see none. Thank you, sir.
Thank you.
All right, we Typically, in this subcommittee, we don't necessarily vote bills out. However, after hearing in the subcommittee, it is available and subject to be called up at the chairman's discretion in full committee. So, thank you, Mr. Washburn. All right, Chairman Perkle. I believe you'll be presenting to us House Bill 1199. You may proceed when you're ready, sir.
Thank you so much. House Bill 1199. This is a committee substitute, LC 460810S. Make sure we're all on the same page. I see blank stares, but I'm assuming that's okay. We got this right number. So my preacher one time, he said, woo, boy, this is a tough audience. The preacher said one time he had, he said in a sermon, he said, there's a man and woman in their kitchen fixing a Thanksgiving meal. And the wife we're making a ham, and she cut off 1 inch of either end of the ham. And he said, why? He said, because that's how Grandma did it. And so he called Grandma, who was still alive, and said, why do you cut 1 inch off either end of the ham? And she said, so it'll fit in the pan. There are some things that we do that we don't hardly understand why. And I have you a bill today that it really, it makes us limited government. It makes us a little bit more efficient. It happens to be a recommendation of the Rural Development Council, but it's just a good bill. So I'm not going to read the 54 lines that we are striking, that you can look on your bill and see what we are striking. That has been in code section since 1970. And monthly, the state auditor provides data for architectural and engineering firms that shows how much each firm has over a 36-month period. They do that monthly because it's required in code. I'm not sure anyone has looked at on the website under the Transparency in Government Act so that we can actually have access to this data. It does indicate on line 70 that one of the statistics that we will gather, in addition to what we're doing now, will speak to the number of contracts awarded to engineering firms in rural parts of the state as well. So that's a bill. Makes us more efficient, and I'll stand for questions. I know we have Ms. Carroll with the State Auditor's Department that wishes to speak to this bill.
Okay, sir, and as far as I can tell, first of all, we have no questions showing, so any questions on the part of the committee? I'll just make a comment. Deleting 54, adding 11, that's a net reduction of 43 lines in state code. That's a very good start.
Good efficiency.
Yes, sir.
Yes, sir.
Okay, seeing no questions on the part of the committee, we will ask Carol Schwinn, if you'd like to come to the podium and proceed when you're ready, ma'am.
Good afternoon. My name is Carol Schwinn, and I'm with the Department of Audits and Accounts, and we appreciate you taking up this bill today, and we are speaking in support of this bill. We've been looking at this legislation or this code section for a while and kind of wondering, you know, who's using this information. We post it every month to our website, and we're like, okay, who is using this information? So we started contacting the agencies. Each month, each agency has to submit information on architectural and engineering firms that they've contracted with. So this is something that is, you know, a burden on each agency on a monthly basis as well. So we contacted them first to see, you know, how are you using this information? And honestly, the majority of the agencies that we contacted said, we are not using this at all. We send you the statistics and we don't think about it for another month. And then we thought we would contact the Department of Administrative Services because they are overseeing our procurement policies, and they actually didn't know that the report existed. So we thought, what is the value of this? And speaking with leadership in both the House and the Senate, we had some conversations about it, and they found that there was some value in providing some information, but not on a monthly basis. And so we kind of came up with an agreement that, what we should do is probably provide some information on an annual basis, using the annual information, the expenditure information, and the contractual information that we get through the TIGA requirements that are already set forth in statute. And we can pull together some information and provide information on Open Georgia, basically giving you an annual overview of what architectural and engineering firms are being contracted with on a year in and year out basis. And we can provide some additional demographics so that you can search to see, what percentage of contracts are being let to firms outside the state of Georgia, or what percentage of contracts are being let to firms that are in rural areas of the state, so that we are providing, opportunities for firms all over the state to do business with Georgia. So we think it's a great bill, and we appreciate you taking it up, and be happy to answer any questions that you have.
Okay, committee, is there any questions? I see none. Thank you.
All right, thank you.
And again, this bill will be eligible to be called up in full committee at the chair's discretion. Representative Matt Reeves, I think you'll be presenting to us House Bill 1113. And you may proceed when you're ready.
Chairman Anderson and members of the subcommittee, I'm proud to present to you House Bill 1113, the Charitable Donor Personal Privacy Protection Act. This bill is filed to encourage free speech and the free exchange of ideas. It benefits donors, but more importantly, it benefits the people and the causes that they give to, which children in need, senior citizens, the arts, many other charitable causes in Georgia. America has a proud history of keeping confidentiality of free speech and giving. For instance, over 200 years ago, with our founding, a lot of our founding fathers wrote under pen names due to having protection from reprisal by governmental authorities. In the 1950s, the U.S. Supreme Court shielded donors to the NAACP from the state of Alabama when the state was trying to get the nonprofit NAACP to divulge the donors in a way that was likely to cause harassment. So that allowed the civil rights movement to go on from the 50s into the 60s. Just 2 years ago, the U.S. Supreme Court again reaffirmed the First Amendment right to confidentiality in a case that was supported by an array of nonprofits, over 300 in total. There are many philanthropic charities here in Atlanta and across the state of Georgia that depend on private giving and private association, and we want to keep it that way through this bill. It's part of our DNA to have charitable giving and to allow people to be anonymous in their charity. Chairman Perkle mentioned something his preacher said, and that reminded me of that saying from the scriptures about sometimes when your right hand is giving, your left hand doesn't need to know that you're giving. And so it's nothing's wrong with having public giving, but there are times when charitable donors want to have confidentiality in giving to nonprofit causes, and this bill protects that. This bill protects all causes. It's neutral. It is not intended to advantage one cause over the other. Everyone has a First Amendment right to privately join and support causes free from harassment and intimidation. We have some witnesses here today to talk about the philanthropic and charitable community and their desire for this bill in Georgia. This is sound policy for our state, and it protects the privacy of donors, which leads to beneficiaries being benefited. 17 states have enacted similar legislation, so this is part of a national movement to protect charitable donors. This prohibits public agencies from compelling nonprofits to provide sensitive information about their membership, support, and volunteers. We have a number of representatives of state agencies who we worked with both before the bill was presented as well as after the bill was dropped. You have a substitute in front of you, LC 560122S that has been revised based on feedback from several state agencies, namely Department of Revenue, Secretary of State, and Department of Banking and Finance. I will acknowledge Department of Human Services brought some ideas to our attention today, and we still are working with them, but this bill is the product of a lot of work. It allows disclosure where statute expressly authorizes that. It does not also impact campaign finance. It explicitly leaves intact campaign finance disclosure and transparency. In that regard, this is about charitable donors and nonprofits that thrive based on confidentiality of donors, unless the donors and the charity want to have a commemoration voluntarily. So that is the bill, and I believe we have other speakers. Thank you for reviewing this bill, and I would respectfully request your support in the full committee.
Okay, do we have any questions on the part of the committee? Okay, I see no questions at this point.
Thank you.
Representative, we'll okay, I'm gonna try this, so I apologize when I don't do this right. Nuala Zaharis. Okay. If I didn't, please correct me when you get to this note. You may proceed when you're ready.
Thank you, Mr. Chairman. Thank you, members of the committee. I'm Nuala Zaharis from the from the Secretary of State's office. I'm the division director for the Charities Division, and we have oversight of charity fundraising activities in Georgia. So as such, protecting our donors is a priority, not only against fraudsters who pretend to be charities to steal money from Georgia donors, but also respecting the integrity and the privacy of our Georgia donors. So as a consumer protection division, we support protecting donor information while also investigating serious violations of the Georgia Charitable Solicitations Act. So we believe that this bill actually balances both of those interests. And we wanted to thank Representative Reeves and Philanthropy Roundtable for including us in that conversation so that we can go after the bad guys and also protect our donors. Thank you.
Thank you. Any questions on the part of the committee? I see none. Thank you very much. And I believe that's everything that is on our agenda. Let's see, was there somebody else that wished to speak? Okay, please come to the podium, and if you don't mind, introduce yourself when you get there, please.
Chair Anderson and members of the subcommittee, thank you for convening today's hearing on House Bill 1113, the Personal Privacy Protection Act. I also want to thank Representative Reeves for sponsoring this important legislation. My name is Alex Biacco, and I'm the Director of Government Affairs at People United for Privacy. Our vision is an America where all people can freely and privately support ideas and nonprofits they believe in, so that all sides of a debate will be heard, individuals won't face retribution for supporting important causes, and all organizations maintain the ability to advance their missions because the privacy of their supporters is protected. I'm a Georgia resident, and I'm honored to discuss the importance of protecting privacy rights with you today. House Bill 1113, the Personal Privacy Protection Act, upholds the First Amendment rights of all Georgians by codifying longstanding practice and U.S. Supreme Court precedent protecting the privacy of nonprofits, members, and supporters. This bill preserves Georgians' right to keep their giving to charities and nonprofit causes private if they wish, and ensures that charitable organizations can continue to safeguard their members' personal information. HB 1113 does so by prohibiting public agencies from collecting or releasing information about a nonprofit organization's members, volunteers, and supporters, except as required by legal proceedings or enforcement of existing law. By adopting this measure, Georgia would join 17 other states that have already acted to bring their privacy protections in line with constitutional protections recently reaffirmed by the U.S. Supreme Court. These states include our neighbors in Alabama, where this policy passed the legislature unanimously just last year, and Tennessee. Recent events have demonstrated the all-too-real safety concerns for supporters of polarizing causes in the center of heated national debates. Even absent a risk of the most extreme consequences, individuals may legitimately fear any number of negative consequences from disclosure, including harassment, adverse government action, and reprisals by an employer, neighbor, or community member. Or they may simply prefer not to have their affiliations revealed publicly or subjected to the possibility of disclosure for a variety of reasons rooted in religious practice, modesty, or a desire to avoid unwanted solicitations. HB 1113 provides necessary proactive protections and safeguards Georgians' freedom to join together with their fellow citizens in support of a cause. It also protects nonprofits that voice an opinion on public policy from having their members targeted for retaliation by those that oppose their views. Importantly, HB 1113 delivers this protection without undermining government transparency and while permitting state agencies to enforce Georgia's laws in a multitude of investigatory and statutorily required contexts. Nonprofit organizations are forces for good and have long played a role in educating Americans and policymakers about complex issues. I respectfully urge the General Assembly to pass HB 1113, the Personal Privacy Protection Act. All Georgians, regardless of their beliefs, will benefit from this legislation's protections for free speech and personal privacy and its strengthening of charitable causes throughout the state. Thank you for your time.
Thank you, sir. Any questions on the part of the committee? Seeing none, is there anyone else who wishes to speak to the bill that we didn't get on the sign-up sheet? Okay, seeing none, Representative Reeves, this will be available as stated before in full committee now, and that's the last bill on our agenda. We will adjourn the state and local subcommittee, and I will vacate the seat and turn it over to Chairman Leverett. Good afternoon, everybody. We'll go ahead and get back and forth. Get it to come on. All right. I don't know if everybody can hear me. I think I'm speaking. Good afternoon. This is the Elections Subcommittee of the House Governmental Affairs Committee. We're all glad to have you with us today. I'm Rob Leverett. I'll be presiding as the chairman of the subcommittee. First person I'm going to recognize is Chairman Buddy DeLoach to take us to the Lord in prayer.
Let's pray. Our Heavenly Father, we are thankful for this opportunity to come here and serve you. May we always remember that we're commanded to love one another, and when we love one another, I suppose we're also commanded to be kind to one another. Let us always remember and do that, and help us to do your will here today. Amen.
Amen. Thank you, Chairman DeLoach. As I'm fond of saying, a prayer to God in what surely must be the voice of God. Thank you very much. All right, we've got a few bills on the agenda today. One's hearing only. I think we're waiting for Senator Burns. Hopefully we'll be here shortly. I'm going to go ahead and recognize Representative Fleming and let him present House Bill 1207 to us. See, podium. All right, Representative Fleming, when you're ready, sir. Thank you for being here.
Thank you, Mr. Chairman. Appreciate y'all having the hearing today on House Bill 1207. Be pretty brief. It's probably be the simplest elections bill y'all have dealt with this session and will deal with. But what 1207 does, it allows candidates, after qualifying, before ballots are printed and loaded on machines, for a period of 24 hours for candidates to proof their ballot, their race, to make sure that all the information they put on their qualifying forms are correct, spelling is correct, parties correct, obviously, district numbers, all that. And this would occur after the state builds the ballots and they send them to the locals, after the local elections boards and directors review and proof the ballots. They would then email the ballots out to the candidates with the email you provided at qualifying, and the email would state that they have 24-hour time period to review that ballot, and the candidates can review them or not review them. If they review them and see that there's maybe a mistake or there's something that needs to be fixed, they have to, within that 24-hour period, to get back with the elections office, let them know their concern or they've caught something. And then once that 24-hour period has lapsed, they can move on with the printing of the ballots. So that's pretty much the bill. I did work with the Secretary of State's office on this, ran it by them. I've talked to several elections officials. Have worked and continue to work with ACCG on some of the things that we talked about as well. But with that, Mr. Chairman, that's the bill, and be happy to answer any questions.
All right, thank you, sir. Do any members of the committee have any questions for the author of the bill? Let's see who was first here. Chairman Hood.
Thank you, Representative Fleming, for bringing the bill. And just in your conversations with the stakeholders, did that include any county election superintendents?
Yes, sir. Yeah, I talked to several county election superintendents as well as we were drafting this, to run the idea initially by them, but also to show them some of the language. For the most part, was very supportive of it. A lot of the superintendents I talked to liked the idea of another set of eyes on the ballots before they sign off on them. So yeah, there was some support for it.
So essentially, the county election office would send a notification via email to the candidates.
That's correct.
Allowing them 24 hours to proof the ballot.
That's correct.
For correct spellings and things like that.
That's correct. Yep,
Okay.
for that race that you have qualified for.
Representative Olalaye.
Thank you, Chair, and appreciate you bringing this bill before us, Rep. Fleming. Love any opportunity to review a ballot before it's printed. Quick question. I know, just following up on Chairman LaHood's comments around the process.
Mm-hmm.
An email would be sent to candidates with, and candidates would have 24 hours to review and provide any comments
Mm-hmm.
or suggested edits to the ballot before they're printed.
Just to their race.
Just to their race.
To their
Correct.
specific name and race, yes.
Correct. Would there be any attempt to set that date or create a standing date in advance that could be communicated to candidates so that they would have some forewarning that the email is coming. My only concern is, you know, we're inundated with a ton of emails, and that's an important email that I imagine most candidates would want to know is coming.
Yeah, no, absolutely. I think that's a great point. It needs to be a standard date. Obviously, that date would be different every election based on the date, but I think that's something the Secretary of State's office could set. You know, notify the candidates in the counties when that date would be each year for each race. Yeah.
Appreciate it.
Thank you, Representative. Representative Roberts.
Thank you, Mr. Chair. I guess, can you just educate me on typically what the time frame is from when the state builds the ballot and then how early they have to be printed before an election? Do you know that time frame?
I used to know that like the back of my hand, but that was a former life of mine. But if the chairman's okay, that's Mr. Teasley. If maybe I don't know the exact, but we can get that information. I mean, I think it's about a 2 to 3 week window.
I just was curious what the time frame is from the time the state builds the ballot, communicates it to the county, and then the county sends it to us, and then how long do they have to order the ballot so that it's there in time for the election? I just was trying to understand the time frame of it all.
It is a pretty tight time frame.
I'm not opposed to the bill. I just was curious.
I think it's a legitimate question. General Counsel Charlotte McGowan, we appreciate you being with us today, and I think if you can field that one for us.
Absolutely. And thank you for the question, because that's a critical thing to not put too much time and pressure on our election officials. I would say it's I don't know if there's an exact period of time that's set in our procedures, but it's a window of a couple weeks, maybe 1 or 2 weeks, in order to for the counties to proof the ballots and get them approved.
Okay. Thank you.
Thank you.
Any follow-up, Representative Roberts?
No, thank you,
Okay.
Mr. Chair.
Thank you. All right, any other questions for the sponsor? Nope, I do have one. Chairman Deloach.
Let me just clarify this. I wanted to make sure that prior question that everybody understood that the counties are the ones that print these ballots. So that might not be totally, timelines could vary a little bit from county to county, but they'd be very, very close because of sometimes there's a substantial period of time it takes to print them and get them returned. Is that true?
Yep.
General Counsel McGowan, we're gonna get your steps in today.
So there's two different approval processes. There's the print ballot, and then there's the electronic ballot, and they're reviewing both. So yes, I think the timelines would vary depending on the county, and they do have to order the paper ballots far in advance in order to meet our UOCAVA deadlines. So there is a small window of time to accomplish all of these tasks, and it would be done in a period of a couple weeks. But I think you would see variances between the counties, also depending on the number of candidates that they would have.
Thank you for that. Yeah, that well played, having a seat right there. Representative Bazemore.
Thank you, Mr. Chairman. I just wanted to make sure I understood you to say that the Secretary of State's office is in approving of this, and that you have the counties, or most of the counties?
Well, I've talked to counties. I'm not going to say all the counties are supportive, but I've called some election supervisors from across the state. I've talked to some county elections board chairmen and board members that I just know across the state, and let them see the legislation. And overwhelmingly, they're supportive of it, but they haven't taken an official position on it, no ma'am.
Mm-hmm.
Any follow-up, Representative Bazemore?
So, yes, thank you,
Okay.
Mr. Chair. Is this going to cost any extra for the counties to?
No, ma'am, it shouldn't.
Inform.
No, ma'am,
Okay.
because they're already doing ballot proofing themselves.
Mm-hmm.
So the only thing they'll be doing is sending an email out, and then if there's any edits. So I don't foresee any additional cost to that.
Thank you. Thank you for the bill.
Thank you, Representative. Representative Fleming, just one question that just occurred to me. And I guess this is something that you don't necessarily need to address statutorily, but what if there's an error? what if they discover the error? I guess, would there have to be a second round sent, or I guess we're not requiring it in the statute?
We're not
That would just be-
requiring that, but I would imagine if you're a candidate and you catch there's an error, that superintendent would want to correct it, and then send it back for another approval.
Probably make sure that there's a second set of eyes to look at it.
That's
to
right.
Make sure it's right the second
Yes,
time.
sir.
Yes, sir. Okay. But the bill, the bill doesn't really address that. That would be something that each county could resolve on their own.
That's
or
correct.
Could address by regulation. I
Yes,
suppose.
sir.
Okay. All right. Thank you. Any other questions? All right. Thank you, sir.
Thank y'all. Thank you, Mr. Chairman.
Anyone would like to speak to the bill? Okay. So Chief of Staff Sam Teasley, we appreciate you being here today, Sam. Appreciate all your time. You're always a faithful attendee.
Happy to be here. Thank you, Mr. Chairman. So just a couple of quick things. One, while this isn't legislation that our office asked for or generated, it is something we think is good government, and we appreciate the representative for bringing a good idea forward. And to your question of what happens if it gets caught in the process, that happens now. When we send a first review to the counties, or they send, there's a lot of back and forth now. Hey, we missed, we forgot the I for the incumbent, so that kind of process is already in place. So this would just be an extension of that.
Thank you. Yeah, I suppose that, like all human enterprises, mistakes do happen. Yes, sir. All right. Thank you. All right. Unlike my fellow subcommittee chairman, I do like to take votes on these things. So what's the pleasure of the committee?
Move to pass.
I got a motion to pass. Do I have a second? A second. Any further discussion? All right. All those in favor signify by saying aye. Aye. All opposed? All right. Thank you very much. All right. On to the full committee. All right. I don't believe Senator Burns is here yet.
He actually has a committee that he's starting in 7
Oh,
minutes.
does it? Okay.
Probably need to wait and delay for another day.
Okay. All right. All right. So the hearing only on Senate Bill 189 will likely be postponed because the Chairman Burns, Senator Burns, is actually conducting his own committee meeting right now.
It will be in a few minutes.
Or will be shortly. So unless he walks through the door with his bright smiling face, we'll just let him present that to us on another day. So I'd like to call up House Bill 1112. That is my bill. We had that a hearing on that last week and heard from General Counsel McGowan, and I believe she would like to speak to the bill again today. Just to review, this bill does a few things. It provides for the removal of the secretary from the state election board. Currently, he's an ex officio non-voting member. Moves the state election board to the state accounting office for administrative purposes, authorizes them to hire investigators and the executive director to hire investigators, authorizes them to conduct investigations of local election officials, which is sort of not, I think, really in question at this point, but also of the elections division. And then it has a provision that's is intended to, I guess, confirm the authority of the board to issue letters of reprimand and letters of instruction, which I believe it's currently doing. This just gives them some statutory authority for that. And then also in Code Section 21235, which provides some notices be provided by the state election board if it issues emergency rules, that if the secretary is going to be off that board, he would be one of the parties entitled to be notified of those emergency rules. So that's basically what that bill does. Just to review, the General Counsel McGowan has issued a letter, which I think it was sent to all of you, but I've also shared it with you, or Shannon shared it with you, just confirming her opinion that the bill, or I guess technically Section 2 of the bill is unconstitutional. I've provided you an opinion of the Legislative Counsel's office that it is, and so that's kind of, I guess, the current posture of the discussion. And I believe General Counsel McGowan has signed up to speak today, so I'm going to go ahead and recognize her.
And thank you, General Counsel, for being here with us today. Even if it is to speak against my bill, we're always glad to see you.
Well, thank you for having me, and I know I spoke to the committee last week, or the subcommittee last week, so I won't belabor the point, but I did just want to come and reiterate our position and our opposition to Section 2 of the bill, allowing the state election board to investigate and essentially oversee the Secretary of State, that this would be an unconstitutional violation of the separation of powers, again, because it gives an unelected board of political appointees oversight authority over a constitutional officer. My letter does cite the Attorney General opinion that directly addresses this issue. And I am aware that Legislative Counsel gave you an opinion largely arguing that the Attorney General opinion is outdated because of more recent legislative changes to the structure of the state election board. But I would just like to point out that the opinion itself notes that the Georgia Supreme Court has not addressed whether a statewide elected executive officer is subject to oversight by an appointed board within the executive department. So I think even the opinion from Legislative Counsel admits that would be a constitutional experiment to see whether or not this is lawful. And my other issue with the opinion from Legislative Counsel is that it really glosses over the critical fact that the Secretary of State is a statewide constitutional officer, and that is the main focus of the Attorney General opinion. And the reason that there's a separation of powers issue is because you do have a constitutional officer, and then you have the state election board that is an appointed board of political appointees. And here I'm reading directly from the Attorney General's opinion, focusing on this constitutional question. It says, the Secretary, as a statewide elected, a constitutional officer, enjoys a status in our Republican form of government which transcends that of other appointed officials who may head executive agencies. The power and authority of that office runs directly from a grant by the people through the state constitution itself. And so the General Assembly could not confer upon the board the power or authority to direct the Secretary of State in the performance of the duties of the office without doing violence to the concept of separation of powers in relation to the statewide elected constitutional officer. I will also note that the Attorney General's office has not withdrawn or modified this decision, even in light of the more recent legislative changes. I also would like to make the committee aware of a similar bill involving the labor commissioner that was actually vetoed by Governor Kemp back in 2021 for similar reasons, because the governor found that it did violate the separation of powers in the Constitution, in that it had a board chair that was put and given sort of simultaneous authority with the labor commissioner to conduct the executive duties of the office, and the governor found that that violated the separation of powers. But let's set aside the issue of constitutionality and pretend that it doesn't offend the Constitution. I also just want to raise the question of whether or not this is good policy. And it would be our office's position that it is not. The official who has final say over something as important as our elections should be someone who is directly accountable to the people of Georgia and the voters. And we submit that it would be dangerous to give a board of unelected political appointees that kind of authority over our elections. We submit that also that voters just simply do not want this. And I think what's frustrating is that no one has been able to identify anything that the Secretary of State has actually done wrong that warrants investigation. And so what I would submit is that this appears to be nothing more than an effort to address grievances that still remain from the 2020 election. And in fact, those who are pushing this are the folks who still haven't accepted the results of that election. And there is a very real risk that these same folks will exert pressure on the state election board to interfere with the 2024 election if they don't like the results this time around. So it's very easy to see how this would easily be weaponized by political activists seeking to interfere with our elections. So this isn't good for election administration. It's not good for voters. We simply can't keep relitigating 2020. That has been done. And it is time to move forward. It is the Secretary of State's focus on 2024. We are solely focused on that. We want to make sure that we continue to have safe and secure elections. That is the focus of the Secretary. We think it should be everyone's focus. We think it should be the focus of the State Election Board. There's simply no need to create division between state officials, especially when it comes to our elections. This is a distraction that really nobody needs. And our election officials need to be focused, again, on 2024 and the orderly administration of our primary and general election. So again, I'm asking the committee to consider not just whether this is constitutional, but also whether it is just simply good election policy. I think I did promise some follow-up the last time I was here to some questions. Specifically, what would happen if it did turn out that a state election official had committed a crime or some sort of violation of the law. I did look up that the Attorney General does have the authority to investigate and prosecute crimes that have been committed by the state, including by state officials. That authority is laid out in OCGA 45-15-17. Also, OCGA 45-15-18 allows the governor to ask the Attorney General to investigate. I would say, having previously worked at the Attorney General's office, the investigative part of that usually is done by the GBI because they have the investigative tools. But then if there needed to be any sort of legal action taken or any sort of criminal prosecution, the Attorney General's office is authorized to do that. They would normally seek permission from the governor's office. So if there's a concern about oversight over state officials, that type of oversight already exists in that capacity.
All right, thank you. I was going to ask if there are questions, but I see there is one. Chairman Deloach.
Thank you. The other issue that was raised, I asked the question, and you were going to look at that, and I don't know if you've had time to do it, about what authority the General Assembly would have to investigate, or what authority do they have if they have information that would lead them to believe that there has been some, even if it's just a procedural error that might have made the difference in an election. What authority do they have to look at that?
I believe the very next code section after the ones that I cited deal with the General Assembly's authority to authorize investigations. So I would point you to that section of the code. I apologize, I don't recall specifically off the top of my head, but it does address the General Assembly's authority.
May I follow up, Mr. Chairman?
Yes, sir.
One other issue. As I understand it, we changed the law so that the GBI now has the ability to initiate an investigation on their own. Mm-hmm. Would that also include investigating state constitutional officers in their departments?
What the GBI has authority to investigate is any election anomaly or abnormality that would affect the result of an election. So something that widespread. I think if there was some sort of allegation or evidence that a statewide official was involved in that, that would certainly fall under the GBI's investigative authority.
Thank you. We're learning as we go.
So am I.
Thank you, Chairman Deloach. Any other questions for this witness? I don't see any. If I may respond just on behalf of the opinion that we have before us here from Legislative Council, there is a constitutional provision that grants to the General Assembly authority to prescribe the duties and powers of the Secretary of State. That is limited by some constitutional conferring of duties and powers, so I don't think we can take those away, nor do I believe the State Election Board would ever be able to do that. But I find it hard to conceive how it's unconstitutional for us to set up this framework of oversight when we've got authority to prescribe duties and powers of the Secretary of State. And there's pretty strong authority about our legislative authority being pretty extensive, I guess I would say. And to address your policy concern, I mean, I share those concerns. those who are supporting this bill, if to the extent it includes, if I'm in that Venn diagram, I'm certainly not doing this because I believe the Secretary has committed some great, improper act. I believe it would be good policy to have that check in there. It's not because I believe the Secretary needs it, but one day we may have a Secretary that would need something like that. And this would be a good way to provide that sort of structural overview short of a criminal investigation and indictment. I also think it is a way, frankly, for the Secretary to get some support if he's not doing anything wrong, and the investigation could sort of bolster what he has done. I acknowledge there's a chance they could get in a fight. I think that's probably true anytime you have someone in an oversight position. But I just believe that is outweighed by the positive benefit that could result from that form of oversight. And let me just say again, I do not intend this to be, sort of a statement about any election or about the character of the Secretary. I just think this is a good structural guardrail to put in place that would be beneficial. And I certainly hope that authority would be utilized in that sense. And from my perspective, the extent I feel like it was not being utilized that way would perhaps be a reason to further prescribe it or limit it. But I just don't see the risk of that as that great at this point. So I just want to make sure that you understand my intention, and that the gentleman you work for understands my intention too. So.
No, I appreciate your comments, Mr. Chairman. But having lived through the last 3 years, I don't know if I share your optimism, but appreciate the sentiments.
I'm sure if I had been besieged like you had, I might have a different view of it too, and I respect that. So, Representative Maynard, do you have a question?
Thank you, Chair. The question's for you, not you. My question is we have gone over the bill several times, but for the sake of the listening audience at home, can you briefly do a quick summary of what we're voting on?
Yes, ma'am. There's a number of sections in the bill, 5 to be exact, and so the fifth section just is the standard repealer. So we've got 4 sections that really have substantive provisions. Section 1 would strike from Code Section 21230, the language that makes the Secretary an ex officio non-voting member of the board. So it would basically remove him from the board. And I understand the Secretary doesn't necessarily oppose that. He probably doesn't openly embrace it, but there's no formal opposition there. And then as part of that, the State Election Board has also moved, it's been made a separate budget unit already, but this would move it. It was administratively attached to the Secretary of State's office, and it would move it to the State Accounting Office. The idea is to try to make it more independent, and that's where I think the Ethics Commission resides administratively. So we felt like that was a good home for it. And then also in that section, still modifying the same code section, we provide that the executive director and the board itself are authorized to hire investigators as well as other employees. Then Section 2, that's the one that I think General Counsel McGowan has been focused on. That's the provision that clarifies that or however you like to phrase it, confers a power not previously granted, that the State Election Board has authority to investigate not only local election officials, but the elections division. And I tried to choose that language to, again, make it clear we're not targeting the Secretary as a person. This is just we're trying to provide some oversight of the operations of the election division. Section 3 tries to ratify or provide express statutory authorization for a practice the State Election Board currently, I think, engages in, which is issuing letters of reprimand and letters of instruction rather than, referring for criminal investigation or making findings or taking a stance that would be more, I guess, a fixing of blame. It just says we're issuing a letter of instruction because we think you understandably did it the way you did, but we think it needs to be done differently. And then a letter of reprimand would be where I guess they think whoever did something in a way they think is wrong should have known they should have done it differently. But it's more of a collaborative approach, which I sort of like. And then the final section, there's currently a code section that was part of Senate Bill 202 that provides if the board makes an emergency rule, there are certain elected officials that have to be notified. And since we're taking the secretary off that board, he would then be entitled to also that notice as well. So that's basically a summary of the bill. I hope that was sufficient.
Thank you, Chair. And so just to follow up, the State Elections Board will hire duly qualified investigators, and the duly qualified investigators cannot charge anybody with any crime. They can only send a letter saying there are some technical issues that are not great. We suggest that you correct these technical issues.
I think technically the investigators would report to the State Election Board, and the State Election Board would then make those findings.
And then,
but to your point, there is language requiring them to be qualified in elections matters, the investigators.
And then one last question, if I may.
Yes, ma'am.
And if a letter of reprimand is given, if they find something within the elections division, that is when they then would report it to, say, the Attorney General's office. Because all things may not reach a point where it needs to go to the Attorney General, but if it does, once it does, then the GBI would get involved. I'm just trying to...
Well, I believe that's generally correct, although the bill doesn't mandate any particular course of action. I think that authority is already conferred by general law. If anything, with Section 3, I'm trying to give the board sort of some less nuclear options in its arsenal. But I do believe that, and General Counsel McGowan, from her experience in the AG's office, might be able to address sort of what that progression is. But I do think the State Election Board is not being authorized to issue any kind of, or make any sort of prosecution. That still has to be handled in the AG's office.
Thank you.
If you wish to address that.
Yes, the State Election Board will refer cases if they want to take legal action on them. They will refer them to the Attorney General's office or to the appropriate district attorney.
Thank you. Thank you, Representative Maynard. Did you have any follow-up, or is that okay? All right. Any other questions? All right. General Counsel McGowan, did you wish to say anything further, or?
No, thank you. Thank you for allowing me to speak
All right,
again.
well, thank you. Thank you for being here. All right. Does anyone else wish to speak? Mr. Favorito, would you like to speak to the bill? Sure. Sure. Just hand it to Chairman Deloach there.
I'll be brief. I'm trying not to rehash anything I said last week, but one of the most important things of this bill that we're very much in favor of is the moving the investigations. As I said before, ever since 2007, investigations have been politicized under the Secretary of State's office. One really important thing about this bill is that it moves the investigations to the State Election Board. I'm not clear if it moves all of them or not, or whether there would still be some dual responsibility, but we're certainly in favor of moving them all out. I think it would be much less partisan. In regards, I want to just address the policy concerns that were just raised. I'm not going to debate the constitutional issues, but the State Election Board has 5 separate entities that elect 5 separate members. It is much more independent than having one official in charge of anything, particularly when you have the current questions of our unverifiable voting system. That and I don't know if y'all are aware, but we actually still have an election challenge pending on the May 24th, 2022 primary that hasn't gone to court yet when we challenged the Secretary of State's race. And this has been now 20 months, and we have not even had a hearing on that yet. So the point is, from a policy perspective, I think this bill is actually good policy, not bad policy, because at least you have 5 separate entities appointing the 5 separate board members, not just one questionably elected individual. In regards to there was nothing wrong that the Secretary of State has done, I would just urge everyone to look at voterga.org, and you can find a wealth of things. Let me just mention one thing. Attorney McGowan filed an amicus brief to prevent us from looking at the ballots. These are the counterfeit ballots that we know existed in the Fulton County 2020 race. There was 4 senior poll managers and 2 audit monitors that signed sworn affidavits for it. That was wrong for the people of Georgia. Everyone, doesn't matter whether you're a Republican or Democrat, everyone should have had the right to look at those ballots. So I'm just going to leave it there. I think this is a really good bill, and we certainly support it. And we have been leading this election integrity movement in Georgia for 17 years. Thank you.
Garland, if you would go back, Chairman Deloach is telling me I didn't get you to identify yourself for the record. If you would just do that from the microphone.
Sorry. I'm Garland Favorite. I'm the co-founder of voterga.org. Thank you for asking. I always forget to do that.
All right. I don't see any questions. Thank you. Does anyone else wish to speak to the bill? All right. Well, I would like for us to make a decision on the bill today. We've had a hearing last week and this week, and I've tried to afford everybody an opportunity to be heard because I think that's important. At this time, the chair will entertain a motion. Move to pass. All right, I have a motion. Do I have a second? Second. I have a motion and a second. Any further discussion? All those in favor signify by saying aye. Aye. All those opposed? No.
No.
No? All right, why don't we do a show of hands? All those in favor?
Okay. Wait, oh, sorry. 1, 2,
All right, keep them up, sorry.
6, 8, 1.
All right. All right, and then all those opposed? Okay, 3. So 6-3?
Yes.
All right, so the bill, it will advance to the full committee, so. All right, I don't see Chairman Burns. I suppose he's probably presiding by now. He's waiting on me. Oh, is he? Okay. Yeah. Okay. And I think Chairman LaHood has a bill over there, so I'll let Chairman LaHood get over there. We don't want to seem disrespectful to our Senate colleagues. So, thank you, everyone. I don't believe anything else for the committee today, so we'll stand adjourned. Thank you.